we are going to start the final part of today's session before everyone can go out to the garden and enjoy some well-deserved refreshments with the statements of the legal community of UNIDROIT. That is the legal community with whom we work day to day and with whom we've engaged for 100 years. I keep hearing about the next 100 years. I hope we do last more than 200 years, because it seems like that's the expiry date. So the first is going to be Ms. Flavia Rosenbusch, who, despite that name, is a fellow Spaniard, by the way. She will be representing the World Bank in the name of international organizations. The World Bank works very closely with us because it provides something which is essential for us. They identify on-the-ground needs, especially in developing countries. They realize what is necessary and the laws that need to be provided in order for those countries and those markets to develop and grow on their own. So the World Bank provides a much necessary complement to the standard-setting activity that we purport to undertake. So they are a very good example of the type of organization with whom we work. So please help me welcome the World Bank.
Buonasera. I think that after what you said and the promise of going to the garden, I don't have much to add. È un grandissimo piacere, un onore essere qui per festeggiare il centenario di UNIDROIT. Thank you so much, Excellencies, President of UNIDROIT, Secretary General. UNIDROIT has provided a century of quiet but profound influence on the architecture of private law. It's a celebration of purpose. It's a celebration that fair, predictable, and coherent private law is foundational for economic development and peace. UNIDROIT has recognized that legal fragmentation is a barrier to opportunity. UNIDROIT's response has been thoughtful and practical. This has already been mentioned by other speakers previously. They generate instruments that are rigorous, balanced, and adaptable across legal systems. And that spirit is very much shared by the World Bank. The law has a critical role to play in the bank's mission to eradicate extreme poverty on a livable planet. Let me give you a little bit of framing that most of you probably don't need to hear, but developing economies are facing an investment shortfall of historic proportions. Meeting modest development goals will cost emerging economies about 5% of GDP per year. That's 8% in low-income economies. Even as development needs are rising, investment has diminished. Private investment growth in particular is half the rates that it was in the 2000s, and foreign direct investment has reduced and concentrated in a small handful of economies. At the World Bank, we're sharpening priorities to generate the biggest impact with the limited resources. We have three main pillars going forward. The pillar one is we work on infrastructure. We work, as many of you know, on hard infrastructure. We finance bridges and roads and schools and airports and ports. We also work on soft infrastructure. We finance healthcare, education, job training. The second pillar is private sector engagement. In emerging economies, private, micro, small, and medium-sized enterprises are 90% of the businesses and create 90% of the jobs. Over the next decade, 1.2 billion young people will join the global workforce, while the economies of the world will create less than half that number of jobs. The combined financing capacity of all multilaterals and ODA is a drop in the bucket of needs for emerging economies. So we need the infrastructure, we need private sector, but we need policy. The World Bank identifies the policies that are needed on the ground. Governments need to establish the policies that lay the groundwork for investments. And this is where the collaboration with UNIDROIT has been so strong over this past 60 years, which is the time that the World Bank has existed. All the pillars require a legal ecosystem. It comprises policies, laws, rules, regulations that will need to be implemented and applied fairly, efficiently, consistently, and predictably. What makes the partnership with UNIDROIT so enduring is the shared understanding of how law evolves. It's not through transplantation, but it's through adaptation. We work through principles framed to allow flexibility while safeguarding coherence and trust. This collaboration has brought us last week to think about how to create new legal concept, because we have been working together on carbon markets, as has already been mentioned. This is an example of how leadership and operational partnership can come together. As we look to the future, the partnership will only deepen. UNIDROIT will work on principles of private law, and we, together with UNIDROIT, will be able to implement those principles in a flexible manner in developing countries, which is where they are most needed. On this centenary, allow me to extend our congratulations and our gratitude to UNIDROIT for a century of principled innovation, for your partnership with the World Bank Group, and for continuing to ensure that law serves as a bridge between jurisdictions, between public and private, and between vision and implementation. Happy anniversary.
Okay, so the next group of stakeholders, or the members of the legal community that work with us, is the judiciary, of course, adjudicators. We would put adjudicators into the same bunch, but we have selected a judge in the name of arbitrators as well, because we didn't want to abuse your time. So for that, we have Justice Ole Berger, who is a member, a justice or a judge of the Federal Court of Justice of Germany, and a very good and old friend of this house. He is an expert in many of our instruments. And when he was promoted to the Supreme Court of Germany, we saw the perfect opportunity to invite him and ask him to speak. So please, Ole, the floor is yours.
Excellencies, Mr. President and Mr. Secretary General of UNIDROIT, distinguished guests, and of course my dear friends at UNIDROIT. I feel very much honored to be able to participate in this illustrious celebration. And as the General Secretary has kindly referred to, I'm a former legal officer at UNIDROIT, but I have since returned to Germany to continue my work in the German judiciary. And so I guess this experience puts me in a position to comment on the relevance which UNIDROIT has from the perspective of the judiciary. Of course, you might say that primarily the work of UNIDROIT is dominated by academics, lawyers from national ministries, and private practice practitioners who often deal with cross-border transactions on a daily basis. Judges, on the other hand, and for reasons of the nature of their profession, are typically very much bound to the national legal system and its specific traditions, and they're often less likely to engage in comparative law discourses. So, at least traditionally, I would say that judges have been rare on the floors of Villa Aldo Andini. But this should not lead us to the false conclusion that the work of UNIDROIT is of little relevance to the judiciary. In fact, in my view, it's quite the contrary. While we judges are still trained on the basis of our national codifications or case law, the world around us has changed, obviously. Cross-border commerce has increased enormously. Technical and financial innovations have transformed the way in which transactions are conducted. All of this requires also the law to develop. We as judges could no longer fulfill our function of serving justice in the best interests of the parties involved on the basis of traditional and, I would say, increasingly outdated national legal rules alone. And this is where UNIDROIT in many respects fulfills an important role for the judiciary. Firstly, there is the development of hard law rule through international conventions, which is the classical line of work for UNIDROIT. I'm thinking here, for example, about the highly successful UNIDROIT Cape Town Convention on International Interest in Mobile Equipment and the protocol thereto, which has a profound impact on the financing and leasing of high-value equipment, particularly aircraft, worldwide. The existence of such instruments puts cross-border transactions on a firm and clear legal basis, and thereby also greatly affects the work of every judge who has to deal with such cases. Instead of an often ineffective and unclear legal position on the basis of the application of national conflicts of law rules or substantive private law, we can find a clear legal basis for our decisions in the provision of this treaty if it has become effective in the forum state, which is not everywhere the case, I have to admit. Secondly, the work of UNIDROIT can influence the decision-making of national judiciaries, not only through hard law principles, but also through the development of soft law principles. One of the most prominent examples for such soft law principles developed under the auspices of UNIDROIT are, of course, the UNIDROIT principles on international commercial contracts. These principles are intended to establish a balanced set of rules that can be applied on commercial contracts, regardless of the nationality or residence of the parties, and they seek both to reflect existing common concepts as well as best solutions from individual legal systems of families. And what is now very interesting about these principles from the perspective of the practicing judge is that it's increasingly accepted that these principles can be applied as a tool for the interpretation of cross-border contracts, even if not specifically stipulated for by the parties. So commercial contracts will often contain gaps or ambiguities for which the parties didn't have the time, the budget, patience, whatever, to draft specific rules for. And it would then, of course, be possible for the judge to attempt to solve these issues through the application of purely national methods of interpretation. But this can often lead to inadequate results due to national boundaries and limits of traditional rules of national law. And the UNIDROIT principles are here sometimes regarded as something that is called a global background law that allows to close these gaps through default rules that are specifically adapted for the use in international commercial contracts. A third aspect which demonstrates UNIDROIT's relevance from the perspective of the judiciary is UNIDROIT's role in the dissemination of knowledge, especially the education of judges. Again, we are often confronted with the fact that the education of judges is primarily and sometimes almost exclusively focused on the national legal tradition. This obviously poses a problem in a world where commercial transactions have cross-border elements and where traditional legal solutions are often outdated and lead to unsatisfactory results. And a very important project which addresses these issues is then the UNIDROIT International Program for Law and Development Initiative, which provides knowledge sharing and training for legal professionals, especially for judges from developing states. And I would say, in fact, this project goes even beyond a mere legal training courses. It also promotes the dissemination of international legal instruments developed by UNIDROIT, and most importantly, it also seeks to extend the global community of jurists that are actively interested in legal cooperation and unification. With a final remark, I would like to address why I think that UNIDROIT's working style makes it particularly attractive as a standard-setting body from the perspectives of the judiciary. As already mentioned, a judge's view on the law is typically focused on his or her own national system. Moreover, our profession is also often averse to change, and this often for good reason, since discarding existing precedent would mean throwing away judicial experience and endanger the important objective of legal certainty. In short, whenever the need arises to reform the law and to adopt new solutions, the objectives of such law reform should be set out in very clear terms, and it helps when it explained how the new regime is related to existing principles. This really helps acceptance by judiciary. And this is where UNIDROIT, I would say, excels. It's due to the strong academic background of UNIDROIT, its tradition of combining legal scholarship from a variety of legal families worldwide. This all ensures that UNIDROIT's instruments can be understood and be applied by national judges before the background of their diverse national legal system. So in conclusion, in terms of a headcount, UNIDROIT may still be smaller than the other international institutions. From the perspectives of judiciary, however, I would say it's a very important institution, and for 100 years it has now been a model for international cooperation on the basis of mutual understanding and the free exchange of thought. And I would say on the basis of these working principles, I'm certain that UNIDROIT will continue its success story for the next century. And to add something based on my personal experience, I would also very much invite and very strongly all national judiciaries to engage with the world of UNIDROIT and this marvelous institute, its marvelous persons here, and obviously also the very, very nice rooms. Thank you very much.
Thank you very much, Your Honor. So the next speaker is going to represent academia. UNIDROIT is of the intergovernmental organizations that work in the private law, transnational law sphere, by large, the most academic of all. It was, as we said before, founded as a legal think tank, and we have a whole range of academic institutes and very long-standing academic cooperation with universities from all over the world. To speak on their behalf, we have with us Professor Louis Gollifer, King's Counsel, Fellow of the British Academy, and the Dean of the Faculty of Laws of the University of Cambridge. Louis, please.
Excellencies, distinguished guests, colleagues and friends. Now, I am very greatly honoured to be asked to speak tonight on behalf of the academic community. And looking round, I can see quite a lot of other members of the academic community, which make me feel even more honoured and perhaps rather daunted to be speaking on their behalf. I would like, first of all, to bring greetings and congratulations to UNIDROIT from my own University of Cambridge, but also, of course, from the entire community of academics and students throughout the world. I think we must include students within the academic community as well. Now, I'd like to congratulate UNIDROIT on this important milestone, and what I thought I would do is reflect just a little bit on the important interaction between UNIDROIT and the academic community in the past, the present, and the future. And I think my thesis is that this interaction doesn't just help UNIDROIT and forward its work, but also brings enormous benefit to the academic community itself. And the contribution of the work of UNIDROIT to the intellectual conceptualization of private law really cannot be overstated. So I'd like to suggest that there are at least three aspects of the interaction between UNIDROIT and the academic community that I can mention. First of all, we've already heard from many speakers, particularly the Secretary General, that UNIDROIT owes its very existence to the work and vision of scholars. And in those early days as a think tank, there were study groups that really consisted of eminent academics developing ideas on legal harmonization based on profound understanding of comparative law. Now, over the years, as we've heard, the emphasis has shifted more to the production of UNIDROIT's own instruments, and that's certainly been my own involvement with UNIDROIT. But the involvement of scholars in those international instruments has not diminished. The expert-based approach of the UNIDROIT methodology means that the working groups whose work lead to the development of those instruments consist of people who are experts in the relevant field in their own right, and they participate in a personal capacity rather than as representatives of states. This means that everyone taking part has the ability to exercise intellectual independence. And it is through that discussion of intellectual independent people that the work of UNIDROIT in developing these instruments is forwarded. So the academics give, if you like, of their expertise to UNIDROIT, but their work with UNIDROIT enriches and deepens their own understanding and scholarly work. The level of thought in these working groups is deep and challenging, feeding into academic thought and discourse. And I think we've already heard from Flavia that we were doing quite a lot of that last week when we are trying to extend the boundaries of what can be personal property to accommodate the incredibly important markets in verified carbon credits. Now, the second aspect that the work of UNIDROIT, about the work of UNIDROIT, is that the work can be the object of scholarly study and analysis by academic scholars and students. So we have many books and articles written about UNIDROIT's publications and interests in instruments by a much wider universe of scholars than just those who've actually been involved in study groups and working groups. Of these books and articles, some are purely analytical, some explore the relationship between an international instrument and a particular national law. And some, as you might expect, are actually critical and take a critical approach to the approach taken by UNIDROIT. But all not only throw light and insight on the work of UNIDROIT, they also further the understanding of particular areas of law and contribute to scholarly discourse in general, inspiring critical discussion and analysis of some of the most difficult areas of private law. And in this regard, I'd like to mention the Uniform Law Review, which is a vehicle for much of this intellectual discussion of the work of UNIDROIT. And then thirdly, there is UNIDROIT's own academic work, now embodied in what is called the UNIDROIT Academy, which brings together academics, students, and legal practitioners in detailed consideration of UNIDROIT's instruments and their theoretical and practical importance. Now, I can't tell you everything it does, or I'd be here all night, but we have academic research projects such as the Cape Town Convention Academic Project, jointly run by UNIDROIT and the University of Cambridge. We have academic institutes in different parts of the world, as we've heard from some other speakers. We have opportunities for the wide discussion and dissemination of information about the work of UNIDROIT by the initiatives such as the International Programme for Law and Development, which we've heard about just now. And perhaps even more important, there are hugely valuable opportunities for scholars and students to visit UNIDROIT and participate in its work under the chair, visitors, and internship programs. This the UNIDROIT Academy epitomizes the interaction between academia and UNIDROIT and illustrates the mutual benefit that I mentioned earlier. Speaking personally, it's always a huge honor to be asked to participate in the role of UNIDROIT. I always feel I get more out of the experience than I can possibly put into it. So I bring thanks to UNIDROIT from the academic community for its part in the development of the law, and bring greetings and congratulations for the last 100 years and best wishes for the next 100 years and beyond. Thank you.
I forgot to say before that this is only the opening of the Centenary. We will have a whole conference devoted to arbitration in October. We will have a whole conference devoted, a grand conference on academy, with a university conference, where we received over 50 papers, and this will be in July. And of course, you are all invited, and I already seen you sign the dates in your calendars. So to finish this part and almost the whole event, we have the last stakeholder group represented here that uses often our instruments, and that is that of the legal profession of lawyers. To speak on behalf of the profession, we are inviting Mr. Franco Gianni of Gianni and Origoni, who will speak for the legal profession. Mr. Gianni. floor is yours.
Well, distinguished guests, esteemed colleagues and friends, it is really an honor for me to speak on this occasion on behalf of the legal profession. We are great utilizers of your work, of your great work, and I'm very happy that the legal profession is contributing also to the activities of UNIDROIT. 100 years is a great celebration, has already been said, and represents not only a symbolic anniversary, but also a milestone that invites reflection, remembrance, and above all, I believe, a look towards the future. Somebody said that 100 years is not enough. I agree, maybe it should be more than that, but at least let's think about the following 100 years. UNIDROIT was founded in 1926 in a period where the world was undergoing profound changes following the disaster and suffering of the First World War. International relations were intensifying, trade law was increasing and was crossing national borders. There was a growing sense of urgency regarding the need for legal instruments capable of accompanying and supporting this new world and this new reality. The idea of harmonizing and unifying private law was not merely ambitious, it was really visionary at that time. UNIDROIT thus established itself as a laboratory of ideas and solutions, a meeting place for different legal traditions between civil law and common law systems, and between cultural and institutional experiences that at that time were far removed one from the other. Its mission was clear: to contribute to the development of a uniform law capable of facilitating trade, reducing uncertainties, and promoting international cooperation. The result of its work has been of the utmost significance. Consider, for example, the principles of international commercial contracts, which have provided economic operators, judges, and arbitrators with a reliable and flexible guide for regulating contractual, complicated relationships. But that is not the only case. There have been many other examples of activity carried out by UNIDROIT, which have generated instruments that have helped to create a common legal language capable of overcoming barriers and differences. This result has been achieved through a method based on listening, expertise, and the search for consensus. In a world often marked by divisions and conflicts, UNIDROIT has demonstrated that it is possible to build bridges through the law, promoting shared solutions that respect diversity without compromising effectiveness. Today, more than ever, UNIDROIT's role appears central. We live in a period where globalization dominates markets, yet the geopolitical tensions, economic inequalities, and challenges linked to sustainability and digital transformation render the balance that we have achieved really fragile. In this scenario, the law must play a fundamental role. Force and abuse of power must not prevail. The rule of law shall prevail. It is essential to rebuild trust between states, between economic operators, and between citizens. UNIDROIT, with its experience and authority, can mark a decisive contribution to those objectives. In this context, the contribution of everyone is essential, of the member states, which support and guide the Institute's work, of the experts who make their knowledge available, of academic institutions which foster scientific and intellectual reflection, and of young people who represent the lifeblood of the future. In this regard, let me address a special thought to the younger generation. For those entering the world of international law today, UNIDROIT offers not only a wealth of knowledge, but also an example, that of a constant commitment to dialogue, cooperation, and progress. So as we celebrate the first 100 years, we shall ask ourselves, what kind of UNIDROIT do we want for the next 100 years? What contribution can it make to a constantly evolving world? What tools, what ideas, what energy must we bring to continue to meet the challenges? The values that have guided UNIDROIT since its inception remain more relevant than ever. Cooperation, expertise, openness, respect for diversity, and the pursuit of common good. These are the pillars upon which we build the future. In a world that is often divided, the law can and must be an instrument of unity. It can bring people together, facilitate exchanges, and promote mutual understanding. UNIDROIT has been working toward this for 100 years. Let us continue to support it, to promote it and to make it a point of reference for present and future generations. Thank you.
Right, so promise 1 minute. It's the closing remarks, just a minute. UNIDROIT is very much its people, and the secret of its success is its people. So I'm going to ask you with a final round of applause when we close, before we go to the garden. I'm going to ask you to honor three persons and one group of people. First of all, we're talking about 100 years, but we have in the room 2 persons who have been working for UNIDROIT for over 40 years. We have here Jorge Sanchez Cordero, our current doyen, the dean, who's been so for over 40 years. We have Arthur Hartkamp, who did it also for over 40 years. And it pains me to say that the third person who has worked for UNIDROIT and with UNIDROIT for over 50 years cannot make it in person for health reasons, but please join me in thanking Sir Roy Good for his 50 years of service. And the final applause is for the actual people of UNIDROIT, the team, all the legal officers and administrative staff and all the interns and everyone who's worked so hard to make this event possible. It's a short 2-hour event, but believe me, it's taken hundreds of hours of work and a lot of patience. So thank you, please join me.